a very detailed sort of environmental law that requires the proper it requires environmental impact statements, and it basically requires a lot of paperwork be properly processed before an activity has taken place. Like, you have to acknowledge the environmental consequences of action. This case argued that when the federal government agreed to work with McCaw, none of these agreements had been made, and so it violated law. And the Ninth Court found in that decision that, in fact, the documents were not sufficient, and told the tribe that they had to redo the paperwork and application in order to hunt. So it wasn't a no, it was just you need to redo your paperwork, essentially. Anderson v. Evans, before this case comes up, McCaw sits down with the federal government. They rewrite their agreements to make it legally sufficient. But at the last second, the McCaw changed. I believe it was the number of whales that they wanted to take. Now, when we're talking about whale hunting here, we're not talking about a great number. It's basically the cap is on 5 whales a year, never with any intention of hitting that cap. They killed exactly 1 whale. The one, like, for the brief period that they had a whale. And it takes quite a long time for the tribe to actually sort of process the whale and be done with it and all that. So, 2001, though, they changed sort of their position. The environmental and conservation groups sue, claiming that the revision violates the Marine Mammal Protection Act, and that was the basis for the 2002 decision, Anderson v. Evans. And this case was about the legality of the hunt in the first place. So, to reach the decision, the court had to consider the impact of the hunt on public safety, local whale populations, and a host of other conservation goals. Now, traditionally, the court has ruled in favor of Native American groups in these matters. There's a host of decisions at both the circuit level and at a Supreme Court level that Native fishermen and hunters are allowed fair and equitable share of local species as long as these practices don't threaten the sustainability of the species. More importantly, in 1986, the Supreme Court ruled in the decision Dion versus the United States that the courts should presume that treaty obligations, like the one that the McCaw have with their whaling rights, are not abrogated by federal law unless Congress explicitly states that the law that they're passing would abrogate or terminate whatever treaty rights. And what's interesting, when in '72 and then subsequent reauthorization of the MMPA, Congress actually had a discussion about the McCaw case and said that they would be exempt from the law. Okay, so congressional history background is that in one of the meetings about reauthorization, Congress says this law doesn't apply. So for the court, to wrap up sort of the background here, is that for the court, they have a rather technical decision to make for a Native American tribe that most people have never heard of. But what's fascinating about the case and why it was significant or relevant is that it really tackles a variety of contemporary sort of problems that I think inform the humanities. How do we deal with multiculturalism and race? And how do we recognize special rights that were given in lieu of horrible treatment of many of these people? And how do you weigh that against sort of the forces of globalization, international law, sort of contemporary concerns? And that was what the court sort of confronted when Anderson v. Evans reaches its desk. Now, the argument that I'm making in this particular research is that the court is discursively negotiating and reproducing this sort of its political authority, and in doing so, they curtail Native American self-determination and sovereignty rights. And how that happens is that they call upon Moby Dick as a cultural sort of authority, as a sublime rhetorical force that discursively marshaled Euro-American fears of the sublime to contain Native American beliefs. Now, I'll explain this in a lot more detail in a second, but the basic point of my argument here is that Moby Dick just isn't an American classic. It is a piece that has really haunted American imagination on a variety of issues. It's been used as a cautionary tale on obviously whaling, but it's also been cautionary tales of the Jewish Holocaust, of the decline of American exceptionalism, of the events of 9/11, that Moby Dick is just more than an example of one of the greatest pieces of American literature. And so what I'm tracking is, within this case, why does Moby Dick arise? And it arises several times in the cause sort of case in advancing their claim to whale, for obvious reasons. It's a whaling case, it's a whaling book. But what's interesting is why it comes up in the court and what does it signal in this particular court decision. So my methodology of approaching this, I don't think it's on this slide, but my methodology or sort of approach to this is I start with sort of a critical race theory perspective, which was born out of the 70s to challenge societal and legal structures by understanding how race and racism is sort of is perpetuated by those legal structures. Out of the critical race theory, which was born out of critical legal studies, and there's a long history of those two sort of schools of thought. Born out of critical race theory, though, were a variety of different groups. You had Latino, Latina, Crit, you had a variety of different groups sort of born of that, and one of them is a tribal Crit. And now, there's not many scholars who define themselves as tribal critical scholars, but there are quite a few of them that meet the sort of basic tenets of it. Like, there's no method. Their sort of central concern is to critically interrogate how Native American groups have lost sovereignty and how racism, how the sort of domination of these Native American groups have occurred both through legal structures and also through sort of the cultural imagination about Native American groups. So that's sort of the line of research that I align my work here with. What I most specifically investigate here, though, is what Moby Dick does rhetorically in this court case. It's not very often, we were talking before the presentation, that sometimes the courts do draw upon literary allusion in their court cases. One study did sort of a content analysis of court cases in LexisNexis, found that Shakespeare, for instance, is one of the most widely cited literary allusions. But in this instance, why I started analyzing Moby Dick was because I originally did an argumentative analysis of the Anderson decision and the Metcalfe decision before it. And legally, the decisions made no sense. And there were a lot of political commentators that said, we don't understand how the court arrived at this decision, given the Dion precedent that I talked about earlier, and a host of other sorts of arguments that were present in the case. So, doing a legal analysis didn't get me anywhere. So I thought initially I kind of wasted a lot of research effort. But I kept coming back to this Moby Dick allusion in the beginning. And so what fascinated me was what sort of possibilities Moby Dick might play in rereading this particular decision. And so when I reread it through sort of the frame of what does Moby Dick do rhetorically for the court, suddenly the case makes a lot more sense. And why and how they came about their decision. So in the beginning of the Anderson decision, Judge Martha Berzon recites the following from chapter 69 in Moby Dick, which is the chapter entitled The Funeral. I don't know if many of you have thumbed through a copy of Moby Dick recently, but there's a part in the story where before they fight Moby Dick or anything like that, they come across a group of whalers that have killed a whale, and its dead carcass is floating in the water. And they sort of lament about what's the symbolism of this dead whale, and it's sort of sign to the sailors. And so the initial part of the court case says, while in life the great whale's body may have been a real terror to his foes, in his death his ghost becomes a powerless panic to the world. And that's not the only reference, that's the beginning of any of the finding of facts. When you get into the first paragraph, there's three other allusions that are relevant to note. The first is